Most people repeat one detail about Meghan's lawsuits and think they understand the whole story. That one detail is real, but it is not the whole record. In the next 9 minutes, I'll walk you through a clear timeline of Meghan's major media-related lawsuits, what the outcomes actually were, and what changed in the media conversation because of those outcomes. No character attacks. No drama framing, just context, court outcomes, and the record. We are doing this in 4 parts. The UK case, the court outcome, the US case, what changed. Part 1 starts now. Part 1. The UK case in plain language. This case began after parts of a private handwritten letter that Meghan Markle wrote to her father were published by the Mail on Sunday, along with related online coverage. Meghan brought legal action against the publisher, Associated Newspapers, arguing that the publication amounted to misuse of private information and also infringed her copyright in the letter. The framing of this case is important. It was not a popularity contest, and it was not a referendum on whether people personally liked or disliked Meghan. The core legal questions were narrow and technical. The court had to determine whether publishing substantial excerpts of a private letter was lawful under UK privacy law, and whether reproducing those excerpts without permission violated copyright protections. Those are legal standards grounded in established principles, not public opinion. The timeline helps clarify how the case unfolded. The claim was filed in 2019. In 2021, the High Court granted summary judgment in Meghan's favour on key issues. Summary judgment is significant because it means the judge concluded there was no need for a full trial on those points. In other words, based on the evidence and the applicable law, the court found that the legal outcome was sufficiently clear that a lengthy trial with witnesses was unnecessary. That is not a minor procedural step. It reflects a judicial determination that the case on those issues was legally straightforward. Later in 2021, the Court of Appeal dismissed the publisher's appeal. This meant that the High Court's ruling remained in place. The appellate court reviewed the legal reasoning and decided there was no basis to overturn it. When an appeal is dismissed, the original judgment stands as the authoritative ruling on those issues. After liability was established, the case moved into what lawyers call the remedy stage. This is often where public understanding becomes distorted. In early 2022, court documents confirmed that nominal privacy damages of £1 were awarded. That figure quickly became the headline because it is simple and memorable. However, nominal damages in privacy cases can serve a symbolic function, recognising a legal wrong even if the financial amount attached to that specific head of damage is small. Importantly, the resolution did not end with that £1. Reporting around the outcome referenced copyright damages and the payment of substantial legal costs. Legal costs in high-profile media cases can be significant, and copyright remedies are separate from privacy damages. Focusing solely on the nominal privacy award ignores the broader financial and legal consequences that flowed from the judgment. So Part 1 ends with a clear summary. The UK case resulted in formal court findings that the publication infringed Meghan's privacy and her copyright. The appellate court allowed that decision to stand, and the remedies involved more than a single symbolic number. The official court record reflects a legal determination on privacy and copyright, not just a viral headline about £1. Part 2. The myth versus the record. Here is the myth. Meghan Markle only won £1, so the case was meaningless. Now here is the record-based correction. The £1 figure refers to nominal damages that were awarded in connection with a privacy claim. Nominal damages are symbolic. They are not meant to reflect the full importance of a legal ruling, and they are not designed to measure public impact. The amount became viral because it is simple, catchy, and easy to repeat online. A single small number makes for a powerful headline, but focusing only on that number strips away the broader legal context. The court's findings went beyond that symbolic award. The judgment addressed whether private information had been misused and whether legal boundaries were crossed. There were also appeal proceedings, and those appellate decisions reinforced key aspects of the original ruling. In addition, reporting at the time made clear that the publisher ultimately accepted defeat and did not pursue the matter further after the appeal outcome. That decision not to continue fighting the case is part of the legal story as well, even if it does not fit neatly into a viral social media post. This situation is a textbook example of how media narratives can form. A detail can be completely accurate on its own and still create a misleading overall impression when presented without context. Saying she only won £1 is factually true in a narrow sense. But when that single detail is used to suggest the case had no substance, no legal weight, or no meaningful outcome, the public is being shown only a fragment of the full picture. If you want to approach stories like this with media literacy, you do not stop at one number or one line from a headline. You look at what the court actually decided, what parts of the ruling were challenged, what happened on appeal, and what the final resolution required from both sides. Legal outcomes are layered and technical. Reducing them to a single pound might make for a memorable talking point, but it does not capture the full legal reality. Part 3. The US defamation case in plain language. Separate from the legal disputes in the United Kingdom, Meghan Markle also faced a lawsuit in the United States that drew significant media attention. This case was brought by her half-sister Samantha Markle, who filed a defamation claim based on statements Meghan made during high-profile interviews and the broader media narrative that followed. Because those interviews were watched around the world and discussed across television, newspapers, and online platforms, any statements made in them carried wide public impact. Samantha argued that certain descriptions of her and their relationship were inaccurate and damaging to her reputation, especially given the global spotlight surrounding Meghan at the time. The lawsuit moved through the federal court system, and in March 2024, a federal judge dismissed the case. A dismissal at that stage does not mean the court conducted a full trial with witnesses and cross-examinations. Instead, it means the judge reviewed the legal arguments and the structure of the complaint and determined that, even if the claims were taken as presented, they did not satisfy the strict legal requirements necessary for a defamation case to proceed. In other words, the court concluded that the lawsuit, as framed, did not clear the legal hurdle required to move forward into the evidence and trial phase. However, that was not the absolute end of the matter. The case entered the appeals process, which allows the losing party to ask a higher court to review the lower court's decision. An appeal does not restart the case from scratch. Rather, appellate judges examine whether the original judge correctly applied the law. In 2025, reporting indicated that arguments were heard at the appellate level, meaning the legal debate shifted from the substance of the personal dispute to the technical interpretation of defamation standards and constitutional protections. This stage focuses heavily on legal reasoning, precedent, and the proper boundaries of free speech. Understanding defamation law is crucial when interpreting outcomes like this. Defamation is not about settling personal disagreements or correcting every perceived slight in public life. It operates within narrow legal boundaries. Courts do not ask whether a statement was hurtful, embarrassing, or widely criticised. They ask whether it was presented as a statement of fact rather than opinion, whether that factual claim can be proven false, and whether it caused legally recognisable harm. When public figures are involved, the bar can be even higher, often requiring proof that the statement was made with knowledge of its falsity or with reckless disregard for the truth. Another important distinction is the difference between fact and opinion. The law treats these categories very differently. Opinions, interpretations, and subjective characterizations are generally protected under free speech principles. Even sharp or critical commentary can fall under protected opinion. Only specific, verifiable factual assertions, statements that can be objectively proven true or false, typically qualify as the foundation for a defamation claim. This distinction can be frustrating for people who view public disputes in moral or emotional terms, but it is central to how courts analyse such cases. Because of this legal framework, it is important to be cautious when interpreting headlines or social media reactions. When a lawsuit is dismissed, it does not automatically mean that the court declared one person completely truthful and the other entirely dishonest. It means that the claim, as presented, did not meet the defined legal standard required to proceed. A dismissal is a procedural and legal determination, not a sweeping moral judgment. It reflects how the law is structured and applied, not necessarily how members of the public may feel about the individuals involved. So when people online say that the dismissal proves Meghan lied, or that it proves her sister's claims were baseless in a broader moral sense, that interpretation stretches beyond what the court actually ruled. The court's role is limited and technical. It applies legal definitions and thresholds. The outcome is a legal result grounded in statutory and constitutional standards, not a public referendum on character or credibility. Part 4. What changed in the media and what did not? Here is the calm answer. What changed is that the UK case produced a permanent court record that can be referenced when coverage becomes distorted. A court record is slower than a headline, but it is sturdier. What did not change is the incentive system. Outrage content still performs. So some outlets and channels will continue to frame these outcomes in ways that serve attention rather than accuracy. So your viewer takeaway is simple, and it applies to every public figure story, not just this one. Separate 3 things: claim, evidence, outcome. If you want more videos in this exact style, subscribe and watch the playlist Claim, Evidence, Outcome. And if you want the next timeline, comment one topic and I'll map it calmly, in order with the record.